Welcome to the deep dive. Our mission today is pretty laser-focused on a situation that feels like it's becoming more and more common. Imagine this. A serious personal injury lawsuit gets filed. On the surface, it looks, pretty routine. But the defendants suspect it's not just one accident. They think it's part of a huge organized scheme. And what's more, they suspect it's all being funded by outside money. So today we are diving deep into a really pivotal decision. It's from the New York Appellate Division, First Department. The case is Lituma et al., the Liberty Coca-Cola Beverages LLC et al. And this ruling is basically a roadmap for you, for any well-informed observer, to understand how courts are reacting when third-party litigation funding, or TPLF, gets tangled up with allegations of systemic fraud.
It's a huge decision. I mean, what it really shows is the New York courts drawing a very clear line in the sand. They're saying, transparency comes first. We need to get to the truth. So the core of this ruling was that they backed up the lower court's decision to basically hit the pause button on the whole case. They vacated the trial readiness declaration and ordered more discovery, a lot more.
Okay, let's unpack that. So we have a case that procedurally was supposedly all buttoned up, ready for a jury. But the defense comes in and convinces the trial court, which, and this is always confusing in New York, is called a Supreme Court, to essentially just rewind the clock.
And that is not a small thing to ask. It really isn't. Once a case is certified as ready for trial, it's very hard to reverse that. You can't just say, oops, I forgot something. The defendants had to prove what the law calls good cause. And in plain English, that means they had to show that some unusual or unanticipated circumstances had come up, something so substantial that it would be, incredibly prejudicial to just go to trial without looking into it. They had to prove something totally unexpected had just surfaced.
Right. So what was it? What was the smoking gun here? What was this new evidence that was so strong it convinced the court to halt everything?
Well, the evidence really centered on a very detailed affidavit. It was from the defendant's insurance agent. And this document didn't just hint at suspicion. It laid out a pretty chilling pattern. It detailed all these financial and structural links between these specific plaintiffs, their doctors, and other people involved in a whole network of other suspicious accidents.
Wow. So they weren't just saying, hey, this one accident might be staged. They were pointing to a potentially organized, full-fledged enterprise.
Precisely. The court wasn't just reacting to, a hunch. They were reacting to actual documented evidence of a pattern, a potential scheme. And what's fascinating is the timing. This is why the court gave the defense a pass on the delay. The Appellate Division pointed out that this evidence, this whole network of links, it only really started to surface about a month before the plaintiffs filed that note of issue.
So right before they said they were ready for trial.
Exactly. The defense was digging all this up right up to the wire. So the Appellate Division said, look, the trial court was completely within its rights. It providently exercised its discretion to vacate that declaration and let the investigation keep going. I mean, you can't go to trial when the entire foundation of the claim might be built on fraud.
Okay, I can definitely see why they'd need more time to investigate the alleged fraud itself. But here's where it gets really interesting and where it becomes a huge marker for the future of litigation finance. The court also allowed the defendants to dig into the funding of the plaintiff's lawsuit. So my question is, why is TPLF funding, who's paying the legal bills? Why is that relevant to whether or not a Coca-Cola truck was in an accident?
And that is the central, I would say, explosive legal question here. It's why this ruling matters so much beyond just this one case. A lot of people assume that litigation funding info is, protected, and often it is. But the court leaned on New York's discovery rule, which is famously broad. It basically requires full disclosure of anything material and necessary to the defense. You can think of it as a show your cards rule. If those cards have any bearing on the real controversy, you have to show them.
But how does who pays the lawyer bear on whether the defendant caused the injury? I'm still stuck on that connection.
It goes directly to motive. The defense made a brilliant argument. They said the funding information was material and necessary because it could reveal a financial motive for fabricating the accident. See, when you inject TPLF, that external capital, into a potentially fraudulent scheme with all these linked players, that money isn't just paying a lawyer anymore. It's potentially financing the entire operation, from the medical referrals to the expert witnesses.
I see. So the TPLF money transforms the case from a simple car crash into an investment. And the defense is arguing they need to see that investment structure to prove the intent to defraud was there from the very beginning.
Exactly right. The court is making an implicit link between the external financing, the TPLF, and the reason the accident was allegedly staged or exaggerated in the first place. That funding becomes directly relevant to the core question of whether any of this was legitimate.
Okay, but hold on. Where does this stop? I mean, if every defense lawyer can just stand up and say, I suspect a pattern of fraud, and then immediately start digging through a plaintiff's financial arrangements, their funding agreements, doesn't that just completely undermine a plaintiff's right to finance their case privately?
That's a critical point, and you're right to raise it. The court did not just swing the doors wide open for limitless discovery. This is exactly why that initial evidence, the affidavit, the documented links between plaintiffs and doctors and other cases was so crucial. The court essentially said, you, the defense, you have to come forward with strong evidence of an organized systemic scheme first. You can't just go on a fishing expedition. But if you meet that high threshold, then the financial engine that's fueling the scheme becomes relevant. It becomes relevant to proving the motive and the scope of the alleged fraud. It's a balance. And, this step really brings New York more in line with other places that are recognizing the unique incentives TPLF can create when fraud is in the mix.
It definitely seems to solidify the idea that if you are a third-party funder in New York's First Department, you need to be very, very confident in the cases you're backing. Because that funding might now be on the table for discovery if fraud is alleged in a credible way.
Oh, absolutely. The risk profile has changed, especially for these mass torts or injury cases where fraud potential is higher.
Now let's quickly touch on the procedural sideshow here. Two of the plaintiffs, Jorge Emerson, Godoy Alvarado, and Amparo Jacqueline Hernandez, they tried a kind of last-ditch effort to fight this discovery order. What were they arguing, and why did the Appellate Division basically refuse to even hear them out?
They tried to dismantle the defense's entire strategy, really. Their argument was that the defendants shouldn't even be allowed to seek discovery based on their fraud claims. They were asserting that those kinds of fraud counterclaims, they just don't belong in what started as a simple personal injury case.
So they were trying to argue that the defense was improperly using a fraud claim just to get wider discovery.
That's a perfect way to put it, yes. They were arguing their case should stay simple and straightforward. But the Appellate Division shut that down for two purely procedural reasons. It really shows how important it is to get your legal strategy right the first time. First, they never appealed the original order from the Supreme Court that allowed the defendants to add the fraud claims to their case in the first place. They just let that foundational ruling stand without a fight. And second, and this is maybe the most telling part, they never even raised this specific argument in their opposition papers for the motion we're talking about today. It's like, if you don't object to the foundation being laid, you can't really complain when they start building the house on top of it.
Sounds like a pretty costly procedural error on their part. What about the issue with the medical exam? They raised something about that too, right?
Yeah, they did. They had an argument about getting reimbursed for the cost of Ms. Hernandez's independent medical exam, the IME. An IME, for our listeners, is when the defense gets to send the plaintiff to a doctor of their choosing to assess the injuries. But the court didn't actually grant the defendants any relief on that specific issue, which means, in legal terms, the plaintiffs weren't aggrieved by that part of the ruling. And since they weren't negatively affected by the court's decision on the IME, the Appellate Division had no reason to consider their counterargument. It was a moot point.
So all those procedural attempts to block discovery just fizzled. Which means the main takeaway remains crystal clear. If there's compelling evidence of systemic fraud, the court will let the defense dig into third-party litigation funding, because those financial details speak directly to the motive behind the fabrication.
That is absolutely the central knowledge nugget for you to take away from this. This decision, which came down in November 2025, it solidifies the view in New York's First Department that TPLF funding is discoverable when the defense can show real evidence linking plaintiffs and providers to a pattern of suspicious accidents. The court is acknowledging that in today's litigation world, financial motives can be the very root of the whole controversy.
And if we zoom out, if we connect this to the bigger picture, this ruling is a really clear signal. It shows the courts will use the broadest interpretation of those discovery rules, New York's show your cards rule, to make sure justice is served, especially when there's a whiff of organized systemic fraud that's potentially being fueled by outside cash. This feels like a very positive step for the integrity of the whole judicial process.
It really forces critical thinking from everyone involved in the system: lawyers, plaintiffs, doctors, and especially the litigation funders themselves. They all have to recognize now that when these highly unusual circumstances pop up, like these detailed links between multiple suspicious accidents, the funding source is no longer automatically off limits. It really underscores the court's commitment to rooting out these alleged schemes that might be relying on that external capital to keep going.
So what does this all mean for the financial world that's backing these lawsuits? Given this huge emphasis on rooting out financial motives in fraud cases, how might greater transparency around TPLF affect how litigation risk is assessed and, priced by third-party funders moving forward? Will they need to invest far more in due diligence and vetting, or risk having their own agreements exposed in court? That's something for you to mull over as the courts continue to peel back the layers of these incredibly complex financial arrangements.